what does Robert H. Jackson mean to, what did that mean to you at the time, if anything? Was that a presence?
Well, sure. I mean, it's physically a presence, at least for most of the time I was there, and that his portrait hung in the SG's office, and it actually hung in the sort of the external formal part of the office over the fireplace. So it had pride of place, and there are a couple of reasons for that. I think one is that there are only so many solicitors general who went on to become attorney general, and it'd be natural in the SG's office to have somebody who went on and did that, because you have portraits of attorneys general. There are no formal portraits, painted portraits of solicitors general. If there were, I mean, Jackson's portrait would be there too. But I'm just saying this sort of limits the universe of potential people for whom it would make a great deal of sense to have their portrait hanging in the SG's office. But there were other candidates, Francis Biddle, for example. Now Jackson has two advantages over Biddle. One, he certainly was a more handsome man. So to the extent that aesthetics matter here, I checked out the Biddle portrait, and I wasn't that excited about it. But I mean, there's also the much more serious and obvious point that Jackson's reputation as Solicitor General, as Attorney General, as a justice, as the Nuremberg prosecutor, I mean, all of that together makes him, I think, an inspiration for all sorts of lawyers in the department, and not the least of which in the SG's office. And not only does his Attorney General portrait hung for most of the time I was there, as I was mentioning, I lost him at the end of my service to Attorney General Mukasey, and it's hard to deny an Attorney General from New York, portrait. But in addition to his Attorney General portrait, there are photographic portraits of all the Solicitors General, and his portrait there hangs in a place of honor in the SG's conference room, along with the, I think, 3 other Solicitors General who went on to serve as justices of the Supreme Court. Mm-hmm. So, kind of any way you look at it, whether as an advocate or as a justice, I mean, there's sort of obvious reasons why Justice Jackson is held in such high regard by the lawyers in the SG's office.
Well, legally, Robert Jackson.
Right.
Yeah.
Why?
Well, he was a master of language as well as of law itself. And he could turn a phrase like no one. And his language was so expressive. And I liked him for that. I never forgave him for publicly condemning Justice Black. He shouldn't have done that. Mm-hmm. Mm-hmm. And it was probably the thing that kept him from being appointed Chief Justice. Mm-hmm. But if I had a mentor, it was he. Mm-hmm. Well, because he was from Jamestown, for one thing.
As you were going through law school, whether it was starting at Ohio Northern and Wayne State and then ultimately Emory, did you read his stuff?
Sure.
Yeah.
Oh, sure.
Yeah. And did you have any reason, being when you got out of the service in 1945, September 45, did you follow the Nuremberg trial?
Oh, very much.
Yeah.
Sure. Sure. And I regretted that he did so poorly in his cross-examination of the big fat fellow.
Goering, yeah.
During the 9 months that I spent in this prison next to Eichmann, preparing the trial for the prosecution, we of course also read through all the Nuremberg reports. And we also quoted some relevant sections and legal arguments and other things during the trial. Yeah. Of course, lots of things were different and lots of things were new. And in the Nuremberg trials, everything having to do with the Holocaust was sort of a marginal point. It was not the central point of the the trial. While here the Eichmann trial dealt with this and all the aspects of the Holocaust. By the way, Mr. Robert Kempner, who was present in Nuremberg, he visited us. We asked him to come to Israel, and I showed him at the end of our investigation. I showed him all he had, and I asked him whether he thought that they had anything at the Nuremberg trials that we missed, and that he felt that we should complete. He said he actually put our minds at rest, and he said that all the important points were there. And then, of course, we had also found, in the meantime, additional evidence, because we had a lot of cooperation from American sources and also from German sources. We received all the documents from all the ministries of the government of Germany, and that also helped us a lot.
Robert H. Jackson is a legendary figure in our country, Pennsylvanian by birth, and most of his activities were in Jamestown, and came to Washington at the request of President Roosevelt in some very troublesome days in our nation's history. He worked at the Internal Revenue Service as general counsel, and then was an assistant attorney general and became attorney general, and a very, very distinguished Supreme Court justice. He has written some of the most often quoted opinions, had a really sense for the core problem, could really move, so to speak, to the jugular in a very graphic, articulate, and memorable way. He wrote one famous line that the Supreme Court is not final because it's infallible. The Supreme Court is infallible because it's final. Which is an honest way of putting it. The Supreme Court captions their writings as opinion of the court. Well, I think that's appropriate. It is their opinions, and they do have the last word. He also coined a very famous expression when he wrote that the Constitution is not a suicide pact. That there are some practical considerations as to what constitutional law means, and there is an ongoing debate as to the role of the Supreme Court. We all agree that the Supreme Court ought not to make the law, they ought to interpret the law. The opinion that I think Justice Jackson is best known for was a concurring opinion in a case called Youngstown Steel, where President Truman seized the steel mills. And one of the really vital parts about our structure in government is separation of powers, that no branch has too much power. And the Supreme Court of the United States decided in 1803 in Marbury versus Madison that the Supreme Court had the final word. Constitution doesn't say that. But when the Supreme Court decided it, they've made it stick for the life of our country, and somebody has to have the final word, and institutionally I think that has worked well for the country. And the Supreme Court has been independent, and notwithstanding Justice Jackson's close relationship with President Roosevelt, and President Roosevelt's appointing him when the famous Korematsu case came up about the internment of Japanese citizens during World War II, Justice Jackson dissented, said that that was an inappropriate and unfair infringement on the constitutional rights of the Japanese citizens. And that dissent and his reasoning in that case have come to be regarded as the appropriate decision. And in the steel seizure case, he wrote a concurring opinion which has been often cited in recent times when the conflict has arisen between the Congress and the President. But Justice Jackson wrote in the concurring opinion in the steel case that the governmental power is at its strongest when the President and the Congress join together. And presidential authority is at a medium point when the Congress has not said one way or another. And presidential authority is at its lowest point where the Congress has said the contrary, that you can't do something like warrantless wiretaps, and the president disagrees and steps in, notwithstanding a congressional statutory provision to the contrary. So in the hearings which we had 3 years ago for Chief Justice Roberts and Justice Alito, Justice Jackson was quoted very frequently in those proceedings, and they were really sort of historic proceedings.
Of course, I also read books on Nuremberg, and every time when we were discussing the creation of ICTY or the creation of the ICC, the Nuremberg principles and the Nuremberg challenge is always in the center of the discussion, with all the positive achievements, because it's, as we know, the mother of all international tribunals, and also its shortcomings and its criticism, because what is very, very important in international justice, we know, applying international principles, that what we are doing is the right thing to do. But it's also very much about perceptions, and this is also the challenges we have today at the ICTY in Yugoslavia, the ICC in African countries, to make sure that people understand why you are doing what you are doing. So outreach and explanations of what you are doing is very important. Of course, the Nuremberg tribunals is the origin of the of international criminal law, international humanitarian law. And when I have the opportunity to, and I'm looking forward to those 2 days where I know that some of the colleagues who were a part of this historical moment will be here. I'm very much looking forward to meet them, because I have not yet had the opportunity to discuss.